And now, Justice Ami Lazaro-Javier, Honorable Justice Stephen Chong, Honorable Justices of the Supreme Court, distinguished guests, ladies and gentlemen. On behalf of the Center for Asian Legal Studies, thank you for joining us today at the Jones Day-CALS Professorial Lecture on the Rule of Law, delivered by Justice Ami Lazaro-Javier on Safeguarding Judicial Independence, Structuring the Rule of Law in the Philippines and Beyond. To begin today's program, I would like to welcome Associate Professor Jacqueline Neo, Director of CALS, to give her introduction. Associate Professor Jacqueline Neo, please.
Good evening, everyone. Honorable judges, distinguished guests, colleagues, and students. A very warm welcome and thank you so much for being here. It's truly wonderful to have so many of you gathered here today for the Jones Day-CALS Visiting Professorship Lecture on the Rule of Law in Asia. Now, this lecture and the visiting professorship behind it was established in 2022 with the generous support of the Jones Day Foundation. The gift enables NUS Law, together with the Center for Asian Legal Studies, to bring leading judges to Singapore. These are individuals who not only study the law, but shape it. And through these engagements, we hope to strengthen our students, faculty, and the wider legal community through the networks and intellectual exchange that we are able to bring together. We are also delighted to have with us Mr. James Fiddler, partner at Jones Day, who will be speaking later and sharing a little bit more about the Jones Day Foundation. Now, this professorship complements the work of the Center for Asian Legal Studies. Since our establishment in 2012, this is the first center of its kind, I must emphasize, in Asia. We have been guided by a very core idea, which is that the study of Asian law should be rooted in Asia. In our view, the region is far too diverse and dynamic to be understood from a distance. It is imperative that we understand each other's systems on our own terms, not only to compare, but to learn and build better solutions together. And here, the rule of law, the emphasis of today's lecture, as well as the visiting professorship, needs to ground our progress and cooperation, and to do so in principles and not just instrumental power. And without it, there can be no order and peace and cooperation that is truly beneficial to all of us. We are, of course, living in a time of rapid change and growing complexity. Our legal systems and political systems are being tested by new economic and security realities, technological disruption, and shifting geopolitical dynamics. But in this landscape, we want to emphasize still that the rule of law will remain our anchor. And as our Court of Appeal has observed in Tan Sik Eng versus Attorney General, the rule of law is the bedrock on which our society was founded and on which it has thrived. Now, this has deep roots in Singapore, going back to the 1826 Second Charter of Justice. And as we mark its bicentennial this year, although much has evolved, our commitment remains constant. Now, we are privileged today to hear from Justice Amy Lazaro-Javier of the Supreme Court of the Philippines, who will be drawing from the Philippines' experience to speak on strengthening judicial independence and public trust. Her public lecture also reminds us that safeguarding the rule of law is a shared endeavor. It calls for dialogue, cooperation, and the exchange of ideas across jurisdiction. It is therefore especially fitting that we are joined this evening by our guest of honor, Justice Stephen Chong. Justice Chong's distinguished career spans across private practice, public service, and the judiciary. In practice, he helped build leading firms grounded in professionalism at Drew & Napier and later at Raja & Tan as their managing partner. His appointment as senior counsel undoubtedly reflects his standing at the bar. Now, on the bench, as Judicial Commissioner and later High Court, he contributed directly to the fair and independent administration of justice. As Attorney General, he strengthened the legal system at an institutional level, reinforcing public confidence and institutional integrity. Today, as a Judge of Appeal of the Supreme Court, he continues to shape Singapore law at the highest level, ensuring that it remains principled, coherent, and responsive. Upholding the rule of law is the clear thread in his career, ensuring a steady and enduring commitment to the rule of law, not just in theory, but in practice. And so, ladies and gentlemen, it is truly an honor to have him here with us today to deliver a welcome speech. Please join me in giving a very warm welcome to Justice Stephen Chong.
Justice Amy Lazaro-Javier, Associate Justice of the Supreme Court of the Philippines, Associate Professor Jacqueline Neo, Director of the Center for Asian Studies, Mr. James Fiddler, Partner Jones Day, distinguished guests. A very good evening to everyone. Let me start by thanking the faculty and the Center for their kind invitation to deliver this opening address. It is indeed my privilege to introduce this year's Jones Day-CALS Visiting Professor on the Rule of Law in Asia, Justice Amy Lazaro-Javier. I understand that Justice Lazaro-Javier will be speaking on the topic of judicial independence, which is a matter of importance to any legal system that is founded on the rule of law. Before turning to judicial independence, I think it is appropriate to take a step back and focus first on the rule of law. The rule of law, as the Chief Justice stated, and as rightly observed by Professor Neo, he stated at the outset of a well-known judgment, is the bedrock on which our society is founded and on which it has thrived. Its precise scope and content is open to disagreement, but it finds expression in various contexts. But the two interrelated fundamental tenets of the rule of law are beyond question. And they are, one, restriction on the arbitrary exercise of power, and B, the equal applicability of the law. Simply understood, it means that no one is above the law. Thus, as between private citizens and individuals, the rule of law contemplates a willingness to submit disputes over rights and liabilities to the fair and impartial resolution by the courts in accordance with the law. And as between private citizens and public institutions, a crucial embodiment of the rule of law is the mechanism of judicial review, which gives tangible form to the idea that even the immense power of the state wielded by the executive and the judiciary is subject to legal limits. It will be clear that the judiciary plays an essential role in upholding the rule of law. In the watershed decision of Marbury against Madison, then U.S. Chief Justice Marshall stated that it was emphatically the province and duty of the judiciary to say what the law is. Indeed, in Singapore, Article 93 of the Constitution vests the judicial power in the judiciary. But the judiciary's ability to safeguard the rule of law is both inherent and cultivated. After all, as Alexander Hamilton famously observed, the judiciary is the weakest of the three arms of government. As unlike the executive and the legislature, the judiciary has no influence over either the sword or the purse and possesses merely judgments. What this means is that the public's willingness to turn to the judiciary to resolve their disputes and to abide by judicial rulings rests entirely on public confidence in the integrity of the judiciary. Simply put, it is incumbent on the judiciary to demonstrate that it is an institution worth reposing trust and confidence in. Its legitimacy entirely hinges on this. And this is where judicial independence comes in. Independence, both as a matter of fact and in terms of appearance, is a necessary requirement for any judiciary that seeks to uphold the rule of law. The willingness of society to submit to and abide by judicial power, and in turn the efficacy of judicial power as a stabilizing force in society, is heavily contingent on the perception of the judiciary being an institution that is neutral and independent, irrespective of who is before it. I do not propose to traverse the topic in significant detail. After all, we are in the very capable hands of Justice Lazaro-Javier for that. What I propose to do instead is to set the stage by laying down a general framework for securing and strengthening judicial independence. This is a topic that can be analyzed from a number of perspectives and from a variety of dimensions. But I would suggest that there are two broad aspects to this matter. The first is institutionalized safeguards, which can be administrative or legal. On the administrative front, one can expect to find features such as administrative independence from other branches of government, as can be seen in Singapore through the formation of a separate Judicial Service Commission. Adequate funding of the judicial branch, fair, objective, and of increasing importance today, inclusive process for the appointment of judicial officers. In terms of legal mechanism, tools to safeguard judicial independence include robust laws against contempt of court, judicial immunity from suit and constitutional guarantees of security of tenure, and adequate remuneration. The overarching aim of these features is to create conducive conditions for fostering independence and impartiality on the part of the judiciary as an institution. But an institution is only as good as the persons who staff it. As the former Chief Justice has observed, we can erect protective walls, but all the protective walls in the world would not be sufficient if the judges themselves are unable or do not wish to exercise personal independence. It is therefore as important as having these safeguards that we ensure on an individual level that each and every judicial officer understands and practices independence in the day-to-day discharge of his or her duty. A football team, as an example, can spend all the money in the world, develop the best facilities, hire the best coaches, but it will win no championship if its players are not up to the task. How then do we cultivate independence in our individual judges? The oath of office that a judge takes in most jurisdictions is a good starting point. While this may differ in different jurisdictions, the core principles are unlikely to diverge significantly. In this regard, the Chief Justice has helpfully distilled two values that an individual judge should abide by, and which I suggest should be ingrained in every serving judge. The first is fortitude. What this means is that the judge must remain steadfast in the face of adversity and pressure. This may come from parties, the media, or the wider public, and indeed it is little exaggeration to say that judges today are under greater scrutiny than ever before. But a judge cannot let this get to him. He cannot let the fear of criticism steer him off course from making a decision which, in his view, is what the law and the facts point to. That would be the very antithesis of independence. And for this reason, I typically avoid reading comments about my decisions on social media. Usually, it's always negative. The second is modesty. Despite what Hamilton said about the judiciary's institutional weakness, it is often said that the pen can be mightier than the sword. That in my view, correctly describes the judicial pen. A judge is in a privileged position. He can, through his or her judgment, shape the development of the law, which is the basis upon which men and women of society make decisions, form expectations, and conduct themselves. But a judge must not lose sight that the maxim that all power has its limits applies equally to all, including the judiciary itself. A judge must therefore maintain a consciousness of the judiciary's proper role in our constitutional framework, and with this be aware of when intervention is appropriate. Moreover, judicial independence does not necessarily refer only to the independence from external influences. A judge must be astute to external influence as he is to his own biases. As the great American judge Benjamin Cardoso said, the judge, even when he's free, is still not wholly free, as he is not to innovate at pleasure, nor is he a knight-errant roaming at will in pursuit of his own idea of beauty or goodness. The judicial role is decidedly not a platform for a judge to assume the mantle of advocate or activist. A judge in one's own cause is no more independent than a judge in another's. I shall confine myself to these brief observations, as we will hear more from Justice Lazaro-Javier, who will speak about the challenges to judicial independence and the rule of law in the Philippines and Asia. Indeed, this seems to be a particularly apposite time for us to hear from the Philippines' perspective. As I understand, the Supreme Court of the Philippines has, at the end of last year, issued a new code of judicial conduct and accountability, which includes at its very first canon no prize for guessing, and that is the principle of independence. So before handing over time, I would like to thank Jones Day for its continued support of this visiting professorship and for making today's event possible. Few topics are of a fundamental importance as the rule of law, and it is heartening to see a commitment to advancing the rule of law in Asia through events like this, which gives us the opportunity of learning from eminent speakers like Justice Lazaro-Javier and to come away with new perspective. Finally, I'd like to express my gratitude to Justice Lazaro-Javier for taking the time to speak to us today. So please, therefore, join me to welcoming Justice Amy Lazaro-Javier to deliver her lecture.
With your kind permission, may I dispense with the acknowledgement and salutation in the interest of time. But with your kind indulgence, I wish to especially acknowledge Justice Stephen Chong and two of my Filipino friends present, former ICC Judge Dean Raul Pangalangan and his wife, Professor Elizabeth Pangalangan, and the officials of the Embassy of the Philippines in Singapore. Thank you. Honored guests, gentlewomen and gentlemen, good evening to all of you. Outside the Philippines, Singapore is the country I have visited the most. I've lost count of the number of visits, though. I've been here sometimes for personal reasons, but many times for official reasons, such as my participation and attendance in the meetings and forums of the Council of ASEAN Chief Justices. Among others, I've interacted with Singapore Supreme Court Justice T. Wee Wee and Justice Debbie Ong, and I just saw him this afternoon, Justice Pang. Your Chief Justice, Honorable Sundaresh Menon, is a beloved friend of the Supreme Court of the Philippines. We deeply admire him as a world-class jurist. leading figure in the international legal community, and a legendary sax player. For me and the Supreme Court of the Philippines, Singapore and its people have a special place in our hearts. Thank you, National University of Singapore Center for Asian Legal Studies, especially Dr. Jacqueline New and Jones Day, for the distinguished opportunity to be here today, doing one of the things dearest to my heart, sharing experiences, knowledge, and learnings. As a teacher of law for 36 years, before I assumed my post in the Supreme Court of the Philippines, nothing brings me more to life than a beautiful and fruitful discourse with young, fresh, and brilliant legal minds like you. Today, most especially, we tackle a topic that sits at the very core of the ongoing grave conflicts in the world that have shaken our communities, the global economy, and most especially, our people's shared commitment to justice, the rule of law, and humanity. And so it is precisely in these times that the rule of law becomes most vital, and its protection and edification by all even more imperative. To help us all truly feel the importance and fragility of the rule of law, allow me to share a short video that powerfully illustrates the rule of law through the lens of the Philippine judiciary, with some powerful words of my colleagues in our Supreme Court.
The rule of law is the foundation of a just society. It ensures that rights are protected, disputes are resolved fairly, and power is exercised within the limits of the law. But for many people, justice remains out of reach.
Sana bigay din nila yung mabilis na hustisya na pantay.
Access to justice remains one of the most pressing challenges confronting our legal system.
Nananawagan ng hustisya.
Hustisya.
Hustisya. Hindi ko po kaya.
Are people still waiting? Women and children seeking protection from violence, families confronting displacement from their homes, indigenous communities fighting to protect their lands and preserve their culture, and individuals facing the full weight of prosecution without counsel beside them.
Justice, after all, is not only about courts and decisions. It is about whether people can access the law that protects them.
These realities demand more than adjudication. They require systemic reform.
In the Philippines, the judiciary plays a critical role in ensuring that the rule of law works for everyone. But this responsibility can only be fulfilled when courts are independent and when judges act with integrity.
We are indebted to no one except the mandate of our office. Our principals are the voiceless, the powerless, the Filipino people, long suffering from the abuse of the powerful.
Judicial independence ensures that decisions are guided not by pressure, but by the Constitution, the law, and the facts. Yet the rule of law cannot exist without public trust.
The rule of law should be the rule of social justice. What must be legal in our hands must be what is just.
Members of the court have also drawn attention to the challenges confronting judicial integrity and public trust, and to the judiciary's duty to combat corruption and remove structural barriers to access to justice through sustained reforms.
Judicial integrity is not a mere philosophical ideal. It is a living ethical commitment. It requires that judges render decisions purely on the law and evidence.
Corruption remains one of the most serious threats to the rule of law.
Corruption not only perpetuates poverty, inequality, and disempowerment, but also deepens the suffering of our people.
This is why the role of judges and all who serve the justice system requires courage.
Strive to achieve not just the rule of law, but the rule of justice.
Because when the rule of law is strong, societies thrive.
The strength of the rule of law lies not merely in the words comprising the statutes, but more so in the faith of the people in the institutions, where they can vindicate their rights without need of taking matters into their own hands.
In the end, the rule of law is not only about courts or constitutions. It is about the people, about trust, about a justice system that remains independent, so that justice can serve every Filipino.
Thank you.
The-
And may I continue? Former United States President Dwight Eisenhower once said, "The clearest way to show what the rule of law means to us in everyday life is to recall what happened when there was no rule of law." History paints this picture very well for us. For example, when tyrannical rulers like Emperor Nero and Caligula brutally executed their enemies without any credible evidence and arbitrarily confiscated their people's property, disregarding established legal procedures. Unfortunately, this is not just a thing in the past. Today, we still hear accounts of grave abuse of authority of those in power, extrajudicial killings, silencing of dissenters, and blatant violations of human rights and due process. Recent violent conflicts have suddenly affected all of us. Life, as we know, has once again changed. World peace threatened, economies destabilized, and the binding force of international law principles challenged. If this chain of events continues, it is not difficult to imagine the chaos and perils that would follow. On this score, let me quote a remarkable American civil rights activist. His name is Roger Nash Baldwin. He profoundly said, "The rule of law in the place of force now takes on a new relevance in a world where, if war is to go, only law can replace it." But the rule of law is not an abstract concept that exists in a vacuum. Strong institutions must be installed and kept in place to protect and enforce it. Foremost of this is the judiciary, the formidable bastion of rights, justice, and fairness for the people. The judiciary is the authority to which the wronged turns for redress, the oppressed seeks relief from oppression, and the weak for protection. And the only way that a judiciary can fulfill this mandate is to become and remain independent, free, beholden to no one and nothing, but the Constitution and the law. The recent study conducted by the United Nations Development Program, or the UNDP, titled Judicial Integrity and Independence in Southeast Asia, determined external and internal influences. that pose as challenges against judicial independence across various jurisdictions in Southeast Asia. In some Asian countries, political influence is present in the form of judicial appointments and reliance on the executive for judicial budget, indirectly affecting the judiciary's impartiality. Other challenges also include the lack of resources in the judiciary, which impairs the capability of judges to effectively undertake their judicial functions. In the Philippines, many of our halls of justice are still located on borrowed lands from the city or municipality, leaving judges vulnerable to undue influence from these local government units. Judicial budgetary independence is also ideal to safeguard judicial integrity, ensuring the judges enjoy sufficient salary and benefits shield them from temptation to receive bribes in exchange for favorable rulings. Another challenge is judicial workload. Where magistrates are saddled with high workloads, the quality of decision-making suffers. Hence, justice served to the people is affected. Even worse, large caseloads may also impact their health and well-being. Judicial security. In several jurisdictions, judges are wary of retaliatory actions against them because of unfavorable decisions. Retaliatory actions may take the form of physical harm or even social media backlash from the people. Historical data show that a number of judges, lawyers, and prosecutors have been killed in the line of duty with ongoing risks from extrajudicial violence and targeted attacks. This underscores the urgent need for robust protection. History has taught us something. It is that when judicial independence erodes, the rule of law soon follows. And when the rule of law collapses, our society will descend into instability, injustice, and conflict. The Philippine judiciary, like in almost every nation, has not been spared from its own set of challenges, manifested by the loss of trust and confidence by the public due to perceived corruption, inaccessibility, erosion of the rule of law, or miscarriage of or delay in justice. Some of our challenges are as follows: partiality or appearance of partiality by magistrates because of corruption, personal bias or prejudice, or political interference. After all, judges are humans too, with their own faults and weaknesses. The scarcity of resources. There are remote areas in the Philippines, for example, that do not have any courts. If you remember, we are 7,100 islands during high tide. But during low tide, it balloons to 7,900 islands. These are remote areas in the Philippines, many of them. They don't have courts, giving rise to inaccessibility to justice for the communities residing in these places. Unfortunately, these communities usually belong to the marginalized sector of society. Due to limited resources, these individuals may opt instead to no longer pursue legal action for any injustice they suffered. The end result, they take the law into their own hands. Many of our courts also suffer from lack of equipment, facilities, or tools to assist judges in the orderly and speedy disposition of cases. There are courts, for example, that are not equipped with stable and fast internet or with updated computers, making it difficult for them to conduct video conferencing hearings or to even digitalize court processes. Clogged courts or clogged dockets of the courts. Because of lack of proper tools and facilities, many courts still use manual instead of digital processes, which cause delay in the resolution of cases. Another notable cause of delayed disposition of cases is the sheer volume of work that our judges are saddled with. For reference, the average caseload of judges in the trial courts in the Philippines is 400 cases per judge. For the Court of Appeals, the average caseload is 350 to 400 cases per justice. And for us in the Supreme Court, our average caseload is 1,000 cases per justice. Judges in the Philippines perform both adjudicatory and administrative tasks, meaning they are expected to hold hearings and resolve cases while at the same time performing management functions in their respective courts. The lack of time then affects the speed and quality of their case disposition, affecting in turn the quality of justice that litigants receive. Another cause is incompetent or negligent judges. As magistrates, we have the duty to sharpen our tools and keep abreast with legal developments. Magistrates who renege on this duty end up dispensing injustice rather than justice, for their rulings are no longer in tune with the law, morals, value, or public good policy. The Supreme Court of the Philippines is aware of these gaps and challenges affecting judicial integrity. As the head of the judiciary, the Supreme Court of the Philippines acknowledges that it has to be the front runner, the first mover to address these problems. As a result, the court, led by Chief Justice Alexander G. Gismundo, deemed it fit to operationalize its own strategic plan for judicial innovations 2022 to 2027, or the SPJI. Before I walk you through the specific reforms we have undertaken, let us watch a short audiovisual presentation that captures the spirit, vision, and key initiatives of the SPJI.
On June 28, 2022, the Supreme Court en banc, led by Chief Justice Alexander G. Gismundo, approved the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI. The SPJI aims to achieve three major outcomes: efficiency, innovation, and access. Under efficiency, the court will undertake to streamline court systems and processes. Some of the proposed activities to achieve efficiency are the judiciary-wide organizational review and restructuring, a system-wide process mapping, a public service continuity plan, the use of an experience-based and data-driven performance metrics and evaluation system, a campaign for ethical responsibility, the organizational review and process mapping of the Judicial Integrity Board, the establishment of mental health units, the institutionalization of a socialized health insurance plan, free or subsidized mandatory physical and mental health examinations for court employees. Under innovation, the judiciary will modernize court processes and operations through technology adaptive management. Some of the proposed activities to achieve innovation are capitalizing on artificial intelligence for legal research and other court operations, developing and deploying the upgraded e-court system, formulating the Judiciary Enterprise ICT Governance Framework, developing a 5-year ICT strategic plan and a Judiciary MIS Operations Manual, developing the network infrastructure for the judiciary, the establishment of a Philippine Judiciary online learning platform which will be administered by the Philippine Judicial Academy, the revision of the rules of court. Under access, the SPJI aims to enhance public access to information and legal services. Some of the proposed activities to achieve access are the development of intelligent platforms for self-help legal services, the continued institutionalization of the clinical legal education program in law school, the strengthening of the IBP legal aid program, the conduct of gender sensitivity and inclusivity reorientation and application workshops considering new laws and issuances like the court's own recent issuance, the guidelines for the use of gender-fair language in the judiciary and gender-fair courtroom etiquette, the issuance of guidelines for victim-sensitive courts, an institutional review and assessment of the Sharia justice system, a review of the Sharia rules of court. While the road ahead may be filled with challenges, we have faith that with all of us working together, the justices, judges, court officials and employees, law practitioners, court users, the academe, the media, and the general public, we can truly achieve this goal of timely justice for all. Efficiency, innovation, access. 3 targeted outcomes towards the ultimate goal of the timely delivery of justice.
Thank you for watching. So under the outcome efficiency, we have the Judiciary Fiscal Autonomy Act. The UNDP report shows that one of the threats to judicial independence and integrity is its dependence on other political entities for the budget that will be given to the judiciary. Fortunately, in the Philippines, the Judiciary Fiscal Autonomy Act was signed into law on August 14, 2025. It enables the Supreme Court to submit its budget proposal directly to the Congress, bypassing the Department of Budget and Management of the Executive Department. It ensures the automatic release of the judiciary's monthly cash requirements without additional paperwork. It also establishes the Judiciary Trust Fund, which allows courts to utilize the collected revenue for operational improvements. The Judiciary Marshals Act. The UNDP also recommended that to further judicial independence and integrity, judiciaries must have security arrangements ensuring the personal protection and safety of judges, and aggravated criminal sanctions for threats to or attacks on judges. This responds to the increased number of judges murdered in recent years in the Philippines. From 1999 to 2017, there were 31 judges who were murdered. Alarmingly, from 2018 to 2021, there were at least 61 lawyers, prosecutors, and judges who were murdered, a figure significantly higher than the record for the past 50 years. Out of 34 cases of judges murdered over 22 years, only 2 were successfully resolved. The Office of the Judiciary Marshal was created to ensure the security, safety, and protection of the members, officials, personnel, and property of the judiciary, including the integrity of the courts and its proceedings. It is empowered to investigate crimes committed against members of the judiciary, as well as allegations of graft and corruption within the judicial system. While these foregoing initiatives focus on the external factors affecting judicial integrity, the Philippine Supreme Court also focuses on internal reforms to strengthen the capacity of our judges. This pioneering Philippine law aligns with international best practices and UNDP recommendation for specialized judicial protection services, ensuring our judges can dispense justice without fear of retaliation. The Office of the Regional Court Manager, or the ORCM. The Supreme Court established the Office of the Regional Court Manager, or ORCM, a decentralized system to improve administrative and support services delivery to all trial courts. The main goal of this office is to relieve the members of the judiciary of their administrative tasks, enabling them to focus on their primary duty of adjudication. The pilot implementation of the ORCM represents a critical milestone in the Supreme Court's efforts to modernize and decentralize administrative support for the judiciary. Then we have the Code of Judicial Conduct and Accountability. In November 2025, the court also approved the third part of its three-pronged integrity initiative within the judiciary, the 2025 Code of Judicial Conduct and Accountability. The first and second parts of the initiative are the Code of Professional Responsibility and Accountability and the Code of Conduct and Accountability for court personnel, officials. The Code of Judicial Conduct and Accountability. It provides clearer guidance to members of the bench by expanding accountability measures that link ethical conduct to performance, compliance, and discipline, issuing guidelines on the responsible use of technology and social media, and promoting gender fairness, inclusivity, and sensitivity in judicial behavior and communications. Then we have the judiciary burnout, scale up, and mental health units. Aside from ensuring the physical security of judges, their mental health should be prioritized. After all, one cannot pour from an empty cup. Thus, the key to maintaining the competence and peak performance of members of the judiciary is to safeguard their mental health. On May 30, 2025, the Supreme Court launched a judiciary burnout scale to track the mental health of the members of the bench. The app is inspired by the Guilford-Zimmerman Temperament Survey, which is an American mental health assessment tool. However, we consulted with experts and have carefully adapted this tool to suit the Philippine context. The app considers Filipino cultural values like hiya or sense of shame, pakikisama or getting along with others, and malasakit or empathy, which shape how emotions are experienced and expressed in the Philippines and by the Filipino people. In addition, a mental health unit with a mental health hotline was established. The regional mental health unit for every judicial region will provide comprehensive support services such as online or in-person mental health first aid, psychiatric or psychological consultation, psychosocial support, and confidential counseling for all court personnel. Then, I would like to share with you the additional efficiency measures under SPJI. We have the Philippine Judicial Academy, the Academy for Judges, Lawyers, and Court Personnel, and those who wish to join the judiciary. It complements the mandatory continuing legal education requirement for practicing lawyers. These ensure magistrates and practicing lawyers to remain competent and updated with the newest statutes and jurisprudence. We have special curriculum for our judges depending on the level that they have been appointed to, first level, second level, third level. The Supreme Court, we also have special sessions where we update ourselves with recent, of course, the recent jurisprudence come from us. So we learn it up close and personal, firsthand. But we participate in giving lectures in the sessions and classes sponsored by the PhilJA. And by the way, PhilJA is headed by a retired justice of the Supreme Court and is constantly evolving, adapting other good practices in other countries. Okay. Just this month, the judiciary adopted a 4-day on-site work week with 1-day work from home to conserve energy while maintaining service continuity, rather. Another practical step toward efficiency without compromising access to justice. May I just share that there is another Philippine Supreme Court in Baguio City. Baguio City is the summer capital of the Philippines. It's around 250 miles, I think, away from Manila. And yearly, by way of tradition, since our founding in 1901, we've been holding our summer sessions in Baguio. So we hold oral arguments there. We actually transported the entire Supreme Court to Baguio for the purpose of holding our sessions and holding oral arguments. But this year, we are not holding it because of energy crisis. We have to economize. And so there is no summer session in Baguio. Summer session will be held on Padre Faura, our main office. So I would like to discuss outcome number 2, which is innovation. By 2027, the court envisions a completely paperless judiciary, which the judiciary of Singapore has already done 15 years ago. Thus, one of the intended outcomes of the SPJI is innovation. The following are the projects and activities of the court under this outcome. The guidelines on submission of electronic copies of pleadings and other court submissions. These guidelines mandates the use of electronic filing or e-filing in all trial courts in civil cases. This innovation is meant to make court processes more efficient through the use of technology. With electronic filing, copies of the pleadings, digital copies, will be made readily available to the parties and to judges, thus minimizing delays. The next component of this trust is the launch of court management applications, which envision the availability of a digital dashboard to judges. Through this dashboard, the judge will be able to access the parties' evidence, pleadings, and records. The complete digitalization of the court process will not only assist in the faster resolution of cases, it also introduces transparency in court procedure, minimizing the risk of corruption. Then we have the expanded Judiciary e-library. The Supreme Court also developed an e-library, which was expanded to include real-time updates of issuances, circulars, and jurisprudence, searchable databases of all rules of procedure, jurisprudential updates, and standardized court forms and online Philippine reports. Through this, legal research is now simpler and easier. Accessibility of the decisions of the court fosters transparency and accountability. If people can read our judicial decisions, they will also begin to understand how laws are interpreted and applied. It empowers the people with knowledge of judicial decisions, which form part of the laws of the land, and it also builds public trust in the justice system. We have recently introduced the use of electronic notarization. Recognizing the benefit of electronic notarization, the Supreme Court promulgated the rules on electronic notarization. The notarization will only be made through an electronic notarization facility, a digital tool or application accredited by the Supreme Court of the Philippines. The notarial book, notarial certificate, and seal will also be in electronic form. And we also allow the video conferencing of people who are based in a different country for as long as they go to the Embassy of the Philippines, which is an extension of the jurisdiction of the Philippines. Because of this initiative, the notaries public will be more accessible to the people. There is likewise better record keeping and traceability for electronic notarial acts, as they are now stored digitally. Then we have the video conferencing in its expanded form and remote proceedings. Building on the guidelines on electronic copies and the push toward a paperless judiciary, the court promulgated Administrative Memorandum 241102-SC, allowing the use of video conferencing technology for the remote appearance or testimony of the parties in court proceedings. This was initially institutionalized during the lockdowns and quarantine measure imposed due to COVID-19 pandemic, but is now further expanded for civil, criminal, and special proceedings. This includes safeguards for persons deprived of liberty, priority for bail hearings and minor cases, and protective measures for vulnerable witnesses, directly addressing clogged dockets and geographic barriers while enhancing transparency and efficiency. Then we have the bar examinations, which we have regionalized and digitalized since 2022. You know, I've received this invitation early last year, but I asked to hold it. Okay. I begged off to do it last year because I chaired the 2025 bar examinations. And then I promised that I will do it this year. That's why I'm here. Thank you. So in line with the 5 minutes only? Oh my God. Okay. So the bar exams, all right. So we also have the Unified Legal Aid Service, addition to the services, free services to indigents given by our Integrated Bar of the Philippines, by the Public Assistance Office, and the CLEP. We have a curriculum in the College of Law, which allows our students, third year and fourth year students, to do legal services under the supervision of a professor who is a lawyer. So, in addition, we require under the ULAS, or the Unified Legal Assistance Service, every lawyer in the Philippines or even abroad, our lawyers abroad, to render free legal aid for at least 60 hours. Please don't worry, Judge, Dean, Raul, you are exempt. There are exemptions, okay, due to age and other factors. Okay, so now the gender responsiveness, you know, we launched Her Story Awards. The Her Story Awards is about women in the judiciary who have conquered challenges and have risen above their challenges. We give this every year in order to inspire other women who are aspiring to be in the judiciary and who are in the judiciary. We have to do this because we are working on the equalization of the appointments of women vis-a-vis the appointments of men. Okay. Although in the trial courts we have already achieved, at least actually the ratio is in favor of women, 60 against 40. Men are diminishing species in the trial courts. With due respect, it's just a joke. We don't want to diminish you. Okay. Second, in the appellate courts, the ratio is fast equalizing, but that has yet to trickle up to the Supreme Court. Do you know that in the 125 years of existence of the Supreme Court, out of 98 or 94 members of the court, only 19 female justices have been appointed. So that means 9.3%. So we want to push for a legislation that will equalize the appointments between men and women in the judiciary. Okay. We have specialized rules for priority cases, like the flood control cases. You must have read about this. Okay. The ill-gotten wealth, the AMLA cases, anti-money laundering cases. So, you know, we are just trying to do everything we can to improve the delivery of justice in our country. And we're not leaving any stone unturned towards this goal. So, although we are not exempt to from criticism, whether regarding perceived delays, perceived biases in high-profile cases or calls for faster reforms, the Supreme Court welcomes constructive scrutiny. Indeed, the SPJI itself was born from honest self-assessment of our gaps. By implementing these bold, transparent, and people-centered innovations, we directly respond to such concerns and reaffirm our sacred mandate. In the Philippines, judicial power is not true power. If at all, its power is a mere incident or effect of its duty. Any power the judiciary holds is not wielded for its own sake. The judiciary is that unique branch of government that does not seek to govern, but rather it seeks to protect the rights of the governed. Independence and integrity of the judiciary do not empower. Instead, they empower the people. They do not empower the judiciary, but the people. In other words, judicial independence and integrity are not sources of institutional power, but rather they are sources of public empowerment. A judiciary that is free from political pressure and personal interest is essential not for its own sake, but because it protects the rights and liberties of the people. It is in that independence that citizens find assurance that even against the powerful or the popular, fairness and justice will still have their day. And so to end this lecture, I don't want to see that notice again because I'm ending it right now. Let me once again borrow the words of former President Dwight Eisenhower. He said, "The world no longer has a choice between force and law. If civilization is to survive, it must choose the rule of law." Thank you. Maraming salamat.